We are on the record.
All right, good morning. This is Judge Brown. If you could please state your appearances. So we have plaintiff.
Plaintiff, pardon me, Bob Cercio, CEO, bar number 5247. Also on the phone is Mother Christy Bow.
Thank you. And for Dad?
Good morning, Your Honor. Jessica Friedman, bar number 13486. Also on the phone is Dad Andrew Baptista.
Thank you. All right, so counsel, have you had a chance to speak with each other?
Yes, we spoke last night. Neither of us has authority to keep the status quo. So my client remains asking for a return of the child to the state.
Okay, and did you get a chance to read the opposition that was just filed?
I did, Your Honor, and I have, I believe that our motion, it's basically a factual rebuttal. We stand by our initial motion. We do not believe a written reply is required.
Okay. Did you want to say anything else this morning?
In argument for our position?
Yes.
Okay. I'll keep it brief. We believe that the current situation is a wrongful retention in Missouri, and we're requesting, of course, a pickup order or return of the child with one additional change to the status quo. That is until further order of the court that all visitations take place in Nevada, so we don't have a repeat of the current situation. We stand by the facts that are stated in our motion, and I appreciate that you've read every bit of it. Part of the refusal from father seems to be based off of two things. One is alleging that there is a danger with the COVID-19, basically a health risk to travel. The second is that the child is compromised with the condition called vitiglio, V-I-T-I-G-L-I-O, which is basically a skin pigment condition which is often characterized as an autoimmune disorder. The medical evidence that we found online from the University of Massachusetts, Dr. John Harris, he's one of the leading experts on it, essentially describes as vitiglio. It's not a suppression of the autoimmune system, but an aggressive autoimmune situation that attacks pigments. He has found that the children are not more susceptible to COVID-19 with this. In fact, that he sees a lower exposure to it because of a stronger autoimmune system. That being said, the articles that I read are not scientific studies. It seems to be anecdotal evidence from the doctor. However, I'm sure if you requested more information on it that we could dig up quite a bit. So we don't find either of those safety arguments controlling. And on the last paragraph of our statement of facts, mother states that she heard from the child, so consider the sources as we weigh this, that the child was free to play with other children. So if father's concern is that it's an exposure to the COVID-19, he's already done that in his own jurisdiction. We are informed that the district attorney's office in Missouri will act upon your order for pickup if you so do it. So we're not talking about an order that would be ignored by the local constabulary. And we believe that you have the jurisdictional power to interpret your orders and to issue as needed. For attorney's fees, we will defer because I think what's coming down, father stated pretty much at the end of March his intention to remain permanently in Missouri. However, it's his burden to prove relocation or to modify custody. We haven't even received a demand on that topic. And with that, I pass to opposing counsel.
I do have one question first. So when Mom went out to Missouri with the child, What was her plan for the next month or two?
She was furloughed for 2 weeks with her office. Her mother lives in Carthage, Missouri. She went out and visited with her family. And the text, talking parents, whatever it is, the emails that I'm looking at make it clear that mother intended to return to Las Vegas. It was not an intention to move to the state of Missouri.
No, I didn't think it was an intention to move. My question was it the plan to stay there during this pandemic?
Only for the duration that her office was closed, and the office reopened on April 3.
Oh, it did reopen. Okay. All right.
Now, they're
not
seeing regular clients. They're seeing the emergency clients consistent with the governor's orders. Nobody's going in for elective procedures at the moment.
But your client is working there?
Yes.
Okay. All right. Thank you. Ms. Friedman?
Yes, Your Honor. So I too did a bit of research on Vitiglio, and much like counsel, everything that we've read is not scientific either. However, the Mayo Clinic and a few other agencies do classify one of the causes of this disease as a weakened immune system. Now, of course, there aren't enough studies. The coronavirus is new, and everyone is doing an abundance of research on the topic. The issue that Dad raises, and is a legitimate one, is that exposing the child to travel and an abundance of people with potentially a weakened immune system, increases the likelihood of the child contracting the disease. And he did a bit of research on his own. There are, the numbers get updated every day, but the number of cases in the counties that he's in Missouri versus Clark County are apples and oranges. And in regards to the allegation that the child told the mother that she was socializing with other children, that's not true. I suppose it's a bit of a he said, she said coming from the child's mouth, but it's Dad's position that simply didn't happen. Dad is taking every precaution to make sure that the child adheres to the stay-at-home orders and is not exposing herself to any outside involvement. So what Dad is asking for is that the child simply remain in Missouri until the stay-at-home order is lifted, which right now we're all under advisement that is going to take place April 30th, and I'm sure all of us hope that that's going to take place April 30th. Mom would obviously be entitled to makeup time. Counsel is correct that Dad did take a permanent job in Missouri, and that a motion for relocation and or modification of custody in all likelihood is forthcoming. The good news for this particular family is school is out of session, obviously, until sometime next year, and so we can be creative in orders from now until then. What Dad is, because obviously the week-on, week-off schedule that Your Honor has ordered previously isn't feasible now that the parties live in two different states. So while that would be ideal, it's simply not feasible. So what Dad is requesting is temporarily until a further order is made regarding motion for modification and or relocation is 30 days on, 30 days off. But obviously, since Mom is working in Las Vegas, Nevada, and Dad is working in Missouri, that the respective timeshare take place in those respective cities. Asking Dad to exercise his timeshare, 100% of his timeshare in Las Vegas is not only cost prohibitive, considering the fact that he lives in Missouri, but it's just simply not feasible because he's working in a different state. So, in conclusion, Dad's simply asking for the child to remain, hopefully it's, the 14th, 2 more weeks now in Missouri until the stay-at-home order is lifted. Mom will then exercise the next 30 or so days in Las Vegas, and then it will, go 30 days on, 30 days off until a future order is implemented. So that's what Dad is asking for today.
Responsive to that, essentially that works out to be a de facto, a unilateral and de facto change in the custody without a filing before the court and at the last minute notice. None of this was communicated prior to father's statement to mother that he was going to permanently stay in Missouri. There are also safe ways to travel, including car travel. In this case, you may recall from the trial, there's a long history of the child being transported by car between the two states. We just don't see the same flames of Paris that father raises in this. If somebody can move, can have movers come into the house and bring in new furniture, that they can go to the store, that they can drive around and mix in the population just like the people are here in Nevada, we see no substantive difference, and that the current orders of the court must be enforced. Thank you.
So what's Mom's request? She wants all visitation in Nevada?
We don't want the child transported back and forth, but father has done nothing on his side of the case to permit a unilateral move to Missouri. We see this as a move of self-help, not one of safety, and the child should be returned to the state. If he wants to reconsider his position about where he lives, he's glad to do so. But he voluntarily moved to Missouri, and also within the facts, the manner in which he took the child to Missouri was on about 6 hours of notice, and that's stated in the facts where he informed mother, the child's going with me to Missouri. That is what prompted mother to eventually go to Carthage to stay with her mother for the period of time that her office was closed. We think
Okay.
the child should be here. That's the bottom line.
Thank you.
All right, anything else?
Your Honor, just one more factual tidbit. It's upon information and belief, Mom has stated that she has had plans during this upcoming summer to spend some time in Missouri. So I don't know what that entails, if that was a weekend or an extended period of stay, but just food for thought that Mom, too, has relayed the fact that she will be coming from Missouri at some point in time during this upcoming summer.
Okay. All right, so I just want to talk about the technicalities right now. The only thing in front of me is the request for the pickup order, and I have an opposition. I do not have a proper counter motion, so the only thing I'm deciding is the pickup order. At this point in time, there's a valid court order from Nevada. The child is a resident of Nevada. Mom is in Nevada. Dad has apparently moved to Missouri. At this point in time, I'm granting the pickup order. The child will be returned immediately to Nevada, her home state. And I'm not making any decisions regarding any change of visitation because there's nothing in front of me that asks me to do that. So the orders remain the same. I would encourage counsel to talk to each other and work something out. Otherwise, I'm sure I will be hearing this again in the near future. So the pickup order is granted. I'm hopeful that you can just agree on an exchange time and place so that you do not have to get the authorities involved. However, it's granted. So with that, again, I highly encourage counsel to talk to each other, to come up with some interim orders if necessary. And we'll defer the
counsel and I will speak with each other when we're done this phone call, Your Honor.
Okay, perfect. All right. I will say that the pickup order is going to be pretty basic. There were some findings in the one that was submitted originally that were beyond what I would normally order.
Would you like it in Word so you can edit it?
That would be fine.
I'll copy opposing counsel with that communication.
Ms. Friedman, do you think a pickup order is going to be necessary?
I don't, Your Honor. I will advise my client that pursuant to your order to return the child.
Okay. I would just hate for the law enforcement to get involved if it's not necessary. It just causes more problems for them, for the parties, I mean.
It will not be a problem between counsel. We've known each other for a while, although this is our first case. We are very respectful towards each other, so there will be no inflaming of the matter through counsel.
Okay. All right. With that, I hope everyone stays safe, and we're adjourned. Thank you.
Thank you for your time, Your Honor.
Thank you, Your Honor.